Hello and welcome to Bioethics and the Law. I'm Dr. Jacob Appel, and I'll be your guide through the next 10 weeks, but you are welcome to call me Jacob. The first week of this course is by far the most challenging because some of you have substantial backgrounds in law. Some of you, in fact, are lawyers, and for others of you, the law is a fairly new and relatively challenging field. One of my goals in the course is for you to be exposed to the primary materials and to read some of the case law. I assure you that you do not need to fully understand the cases or the legal system to do perfectly well in this course. Some of you will explore these cases in great depth, and others of you will have a basic understanding of what occurs in them, and both are fine. The readings are designed to let you explore at the depth you desire. This first week, we're going to spend a bit of time covering the basics of the legal system, and then we're going to apply that understanding to some of the primary cases in reproduction and the law. I want to begin by speaking a bit about the structure of the legal system. As you may remember from high school or college, the United States is a federal system. This means that in certain areas, the federal government has authority to make decisions, and in other areas, the state governments have authority to make decisions. We speak of the federal government as one of enumerated powers, meaning only things that are enumerated in the Constitution as falling under the authority of the federal government is the federal government allowed to do. But over time, the authority of the federal government has expanded in two ways. First, Congress has enacted laws that tell the states to do certain things, with a threat that if they don't do them, they won't receive federal funding. So, for example, federal government has told the states to raise the drinking age to 21 and to set regulations on highway speeds, with the threat that if they don't do so, they won't get federal highway funds. And secondly, the courts have expanded the authority of the federal government. For example, there's a provision in the Constitution that gives the federal government the right to control interstate commerce. And you may wonder what interstate commerce is. Well, the courts have interpreted it extremely broadly. So, for example, the courts have found in Wickard versus Filburn that a man growing wheat on his own farm was engaged in interstate commerce because he affected the international price of wheat. And in Kattenberg versus McClung, the court found that a barbecue, Ollie's Barbecue, that discriminated against black customers was engaged in interstate commerce and therefore could be regulated by the federal government because, among other things, who ate there affected who ate elsewhere, and therefore also affected restaurant consumption in the grander scheme of interstate commerce. In areas where the federal government has authority, the federal government's rules trump state law. But in areas where the federal government either doesn't have authority or has chosen not to act, then state laws are dominant, and state laws always trump local laws. So when examining a legal case, you want to figure out what kind of case it is. The first thing you want to ask is, what is the jurisdiction of the case? Is it a case that is occurring in a federal court or addressing federal law? Is it a case that is occurring in a state court or addressing state law? Or is it a case occurring in a local court addressing local law? And then you want to think about the sources of the law at question. Is the source of law the Constitution itself? Is it a statute, a law passed by either the Congress or the state legislature? Is it an administrative code enacted by an agency? Or is it a common law ruling enacted by a judge? And we'll talk about what each of those are in a moment. And then you want to ask yourself, is it a criminal case? Has someone been charged with a crime? Or is it a civil case, a disagreement between two parties? And finally, if it's a civil case, is it a case about a contract, meaning an agreement between two parties? Or is it what is known as a tort case, where one party is injured another without an agreement between them beforehand? I want to emphasize that again because it's a good take-home message from the first half of this lecture. When looking at a case, and you can look at each of the cases we're going to look at this week, you want to ask yourself 4 questions. What is the jurisdiction? Is it federal, state, or local? What is the source of law? Is it constitutional, statutory, regulatory, or common law? Is it a criminal or a civil case? And if it's a civil case, is it a contract case or a tort case? Now to review that in a bit more detail. So we want to ask first where the law comes from. So some rules are written into the Constitution itself. So if the question is whether or not the state can regulate the right to free speech, we would look at the First Amendment to the Constitution. A number of the cases we're going to look at today relating to reproductive freedom relate to the 14th Amendment to the Constitution. The question at hand could be a law passed by the legislature. And the question could be either whether the legislative act is consistent with the Constitution, and if it's not, it would be struck down, or what the meaning of the legislative act is. Congress could pass a law, or the state legislature could pass a law where the precise meaning is unclear. Then there's the question of administrative law. Sometimes Congress passes a law, or the state legislature passes a law, but it doesn't fill in the details, and that falls to agencies. So an example from my state of New York, for many years, the statutory language in New York State said that doctors had to report child abuse. But it didn't say whether that was only child abuse that occurred during the course of their medical practice, or whether or not they discovered it in their private lives. For example, they heard their neighbor abusing a child. Eventually, an administrative agency in New York filled in the details and explained this was only a regulation that occurred if you discovered the child abuse during the course of your practice, and not in a private or social setting. And finally, there is common law. Common law is law usually that arises in civil litigation or malpractice cases where the judges fill in the gaps. They decide if the legislature says that something is only permissible if reasonable, exactly what is meant by reasonable. And this is known as common law or court-made law. The court can't overturn the statute or the Constitution on its own will, but it can fill in the gaps when things are unclear. And finally, you want to think about the difference between civil cases and criminal cases. In civil cases, two parties are suing each other. The suing party is known as the plaintiff, and the party being sued is known as the defendant. Very few rights kick in. For example, when you have a right to an attorney under the Constitution, that means in a criminal case, not in a civil case. And unlike in Great Britain, where the losing party often pays the bill, in the United States, you have to pay your own way. As a result, many cases are taken on contingency, where a law firm agrees to put up the cost in advance in return for receiving a certain part of the payout if they win. It's a pure adversarial process, meaning the duty of the plaintiff and the defendant are largely the same, to present their own case as best as they can. In contrast, a criminal case is one in which the state, meaning either the federal or state or local government, is prosecuting an individual for committing a crime. And it's often fashioned, for example, as the people or the United States or the Attorney General against a particular defendant. And here, constitutional rights do kick in. Your right to an attorney, your right to trial by jury. And here, the duties of the prosecutor and the defendant and the defense attorney are different, because the goal of the defense attorney is to mount the strongest defense possible within the ethics of the law, while the duty of the prosecutor is only to prosecute the case if they believe a crime has actually occurred and the defendant is actually guilty of that crime. They have a duty to truth, not just a duty to win. And finally, in civil cases, you should be aware of the difference between contract cases and tort cases. Contract cases, which used to be the only cases that arose in medical law, are cases in which the doctor and the patient have a pre-existing agreement or a contract, and the question for the court is to decide what the contract said and how to apply it. More recently, we've seen the development of tort law, or what we might call malpractice law or negligence law, which are cases when there isn't a contract between the two parties. The court to decide what the standard of care was, what the expectation was upon the doctor. And a principle we'll cover later on in this course is that you can't contract out of the standard of care. So if the normal practice is to do surgery with a scalpel in an operating room, but I offer you a discount to do it with a cleaver in the lobby of the hospital, even if you fully understand the risks, you still can't agree to that. And if you do, and I make a mistake, it's still malpractice. And the last legal concept you should be familiar with is that of standing. Standing is the principle that you have to have a legal claim in a case in order to sue. You have to be harmed in some way. So let us say I am walking down the street one day and I see Queen Elizabeth crossing the street, and horrible thing happens. She's hit by a bus. But she's the queen and she's pretty powerful, so she dusts herself off and says, "Don't worry about it," and walks away. But I say that's a terrible injustice. And I go to court and sue on the queen's behalf because I want to make sure that she gets compensated for her injury. In the United States, I can't do that. If the party who's injured doesn't want to sue, nobody else can sue on their behalf. This is called standing. You have to have a legal claim in a case. Historically, in reproductive rights cases, it was very challenging to demonstrate standing because pregnancy lasts 9 months, and often court cases last many years. So by the time the woman was ready to have her case adjudicated, she'd already given birth to a child. So the courts, particularly in the cases we're going to look at today, have created an exception that if something is likely to recur over and over again, but to avoid standing, they'll still make a ruling in the case. So that ends the brief introduction to the legal system. We will review that over and over again during the course of the semester. Now I will return to the actual content of the first week's session. You may be familiar with the 14th Amendment that was passed after the Civil War. It was one of the Civil Rights Amendments. And the portion of it that is relevant to our course is Section 1 that reads, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws." The second clause, "nor shall any state deprive any person of life, liberty, or property without due process of law," is the crucial one for us here. Because the question is asked, what is meant by liberty here? And there are two different interpretations of this phrase. There's one interpretation, which is known as procedural due process, which says the states can deny you life, liberty, or property as long as they assure you that you get due process of law. As long as you get a fair hearing, once you get a fair hearing, then they can deny you liberty if they want to. That is known as procedural due process, ensuring that people get a fair procedure. But over time, the United States Supreme Court has also interpreted this to mean something which we call substantive due process. It means that there are some things that are so fundamental that the courts can't deny them to you, certain types of liberty and property, even if they do give you due process of law. And this is known as substantive due process. And these are the kinds of rights we're going to be looking at today. So what is liberty, as mentioned in the 14th Amendment? And that's one of the key questions the courts have grappled with. Does it mean economic liberty? Does it mean personal liberty? Does it mean both? Does it mean a wide range of rights? Or is it a narrow range of fundamental principles that the courts have described as fundamental to ordered liberty? And this question first came before the Supreme Court in 1905 in the famous case of Lochner versus New York, which is one of the supplemental readings. No need to read it, but if you're interested in reading it, you can. New York State had passed a law that limited the hours that bakers could work. And Lochner, who was a baker in upstate New York, had a very unusual system because apparently bakers had to work in two shifts, once in the evening to prepare the bread, and the second in the morning to pack and ship the bread. So what he did was he asked his bakers to come in the evening, prepare the bread, stay overnight at the bakery, and then ship it in the morning. So they slept overnight. But interestingly, this was not an abusive system. They were paid for their time sleeping. The bakers actually came out ahead economically. So Lochner challenged this law, saying it was unfair, and it violated the liberty both of him as a baker owner and of the bakers to contract under the 14th Amendment. The majority of the Supreme Court, Justice Peckham, writing for the opinion, said that yes, that contracting for the number of hours you work is a liberty right under the Constitution, and that this law violated this right and was unconstitutional, and struck down the law. A minority of the court agreed with the principle that the Constitution, the 14th Amendment's liberty, meant economic liberty, but they said that under Justice Harlan writing the opinion, the minority opinion, this law was a health law designed to protect the health of the bakers, so it wasn't traditional economic liberty. The opinion that is most interesting is that of Justice Oliver Wendell Holmes, who said the courts were asking the wrong question. It didn't matter whether this was an economic regulation or a health and safety regulation. Liberty under the 14th Amendment didn't mean economic liberty in this broad way. This was a matter to be decided by the legislature, and only the legislature could decide when and how to restrict economic rights. And in this case, they had decided to do so, and they were well within their right to do so. The Lochner principle that liberty under the Constitution meant economic liberty remained the law of the land until the 1930s. It was during the New Deal in a case of West Coast Hotel versus Parrish that the Supreme Court finally ended the Lochner era by upholding a Washington state law that authorized a minimum wage, in essence, allowing the government to regulate the economy once again at the state level through minimum wage and maximum hours laws and the like. It's important to note that during the same period, the courts did not view reproductive freedom as a kind of liberty under the 14th Amendment. So, for example, in the case of Buck versus Bell, Virginia had a statute that authorized the sterilization of so-called feeble-minded individuals. I should emphasize that these individuals were not really cognitively impaired. This was a reflection of deeply misguided eugenic theory, and later the anthropologist Stephen Jay Gould would investigate the cognitive condition of the woman involved in this case, Carrie Buck, and found her to be of perfectly normal intelligence. But at the time, she was believed to be feeble-minded, and Virginia law authorized her sterilization. And the question for the Supreme Court was whether or not this violated liberty under the 14th Amendment. And Justice Holmes, the same Justice Holmes who dissented in the Lochner case, said no. This was not a violation of constitutional rights because this is not what was meant by liberty, and this was also a matter for the legislature. In Buck versus Bell, Justice Holmes famously compared expecting feeble-minded women to be sterilized to make that sacrifice as be analogous to men being drafted and being asked to sacrifice their lives to protect the country in the aftermath of World War I. And the famous quote associated with Holmes in Buck v. Bell, a quote later used by the defense at Nuremberg when the Nazi war criminals tried to compare their own eugenics program to the American program, was the famous quote that 3 generations of imbeciles were enough. The theory that economic liberty rather than personal liberty was ingrained in the 14th Amendment lasted long after Buck versus Bell. And finally, in the 1960s, an effort was made to overturn this principle. And the famous first case in a series of cases is Griswold versus Connecticut. It was a test case in Connecticut designed by Planned Parenthood to challenge a statute, one of the only 2 statutes in the country still, the other being in Massachusetts, that criminalized birth control. And the plaintiffs in this case arranged for themselves to be arrested and charged under the statute. It was a criminal statute, to then have a case to bring to the Supreme Court arguing the statute was unconstitutional because limits on the right to birth control violated liberty under the 14th Amendment. And Justice Douglas writes the majority opinion in this case, finding that there is a constitutional right to birth control. And he says famously, specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together, for better or for worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decision. The case, by the way, only applied to married couples at the time. It was later extended to unmarried couples in Eisenstadt versus Baird. But it's key to point out here that Douglas is struggling to find where in the Constitution the specific right to privacy comes from. So he talks about emanations from penumbras from various different amendments, including the 14th Amendment's right to liberty. The emphasis I want to place here on the word is, as though marriage is a static phenomenon. I will add, by the way, that Justice Douglas was married 4 times, the last time to a graduate student less than half his age who he met at a lecture. So maybe some of his thoughts on the nobility of marriage are questionable. But marriage as a concept has clearly evolved in our lifetime. The concept of gay marriage to Justice Douglas in 1965 was likely unthinkable. So if marriage is evolving, how can it also predate the Constitution in some conceptual way? The dissenting justices, Justice Black and Stewart, in the Griswold case, don't think this law is a good law. And here's a quote from Justice Stewart. He says, "I think this is an uncommonly silly law. As a practical matter, the law is obviously unenforceable, except in the oblique context of the present case," parentheses, meaning that the plaintiffs designed a case to get themselves arrested to challenge it. As a philosophical matter, I believe the use of contraceptives in the relationship of marriage should be left to personal and private choice, based upon each individual's moral, ethical, and religious beliefs. As a matter of social policy, I think professional counsel about methods of birth control should be available to all, so that each individual's choice can be meaningfully made. But we are not asked in this case to say whether we think this law is unwise or even asinine. We are asked to hold that it violates the Constitution, and that I cannot do. And here you will see the underpinnings of a debate that will extend through Roe versus Wade and Planned Parenthood versus Casey, and a number of other cases not even directly related to reproduction, such as gay rights cases and the right to gay marriage, medicinal marijuana cases. The question for some justices is whether or not this is a fundamental right. And for other justices, the view is not a question of whether or not this is a fundamental right, but whether there's constitutional language that authorizes government to do this or not. And here Justice Stewart is saying, I agree with you, it's a terrible law, but it's the job of the legislature to decide which laws are permissible and which laws are not permissible. And in this case, there's nothing in the Constitution that restricts the legislature's right to do it. If you don't like birth control law, go to the legislature of Connecticut and lobby against it. We see the same debate played out in Roe versus Wade, the Supreme Court decision that legalized abortion in the United States. And I should emphasize it legalized abortion by striking down state laws that criminalized abortion. So if Roe versus Wade were overturned today, it would not mean that abortion was illegal throughout the United States. It would mean that in states where the law said it was illegal, those laws would go back into effect. And in states where the law did not criminalize abortion, it would remain legal. The majority of the court, here is Justice Blackmun, finds a 14th Amendment right, the liberty right to abortion. And he says, this right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action as we feel it, or as the district court determined in the 9th Amendment's reservation of rights of the people, is broad enough to encompass a woman's decision whether or not to terminate a pregnancy. The challenge here was that the lower court agreed there was a constitutional right to abortion, but they actually didn't say that it was part of liberty under the 14th Amendment, but found a different basis for it in the 9th Amendment. But Blackmun is saying 14th Amendment liberty includes the right to reproductive decision-making. Justice White, in dissent, echoing the views of Holmes earlier and then Black and Stewart and Griswold, says, in a sensitive area such as this, involving as it does issues over which reasonable men, it's interesting he says men, may easily and heatedly differ, I cannot accept the court's exercise of its clear power of choice by interposing a constitutional barrier to state efforts to protect human life and by investing mothers and doctors with a constitutionally protected right to exterminate it. This issue, for the most part, should be left with the people and the political process the people have devised to govern their affairs. So White is not going as far as Black and Stewart and saying this law is uncommonly silly. It actually seems implicit from his quotes and from what we know otherwise that he actually is opposed to abortion. But he's saying that this is a matter which reasonable people could disagree about, and because it's a matter which reasonable people could disagree about, it's something the legislature should decide. It's not fundamental to ordered liberty. And that is part of the key debate here. Are these rights fundamental to who we are as human beings to protect our freedom and democracy, or are they matters about which reasonable people might disagree? Roe versus Wade, as you may recall or will find in the readings, established a trimester system. In that trimester system, in the first trimester, The states could largely not regulate abortion. In the second semester, they could regulate abortion to protect the life of the mother and for public health reasons. And in the third trimester, they could regulate abortion. Over the next 20 years, conservative presidents, particularly President Reagan and Bush, appointed judges who were expected to overturn Roe v. Wade. Pennsylvania passed a statute that severely limited the rights of women to get an abortion. And it was expected in the case of Planned Parenthood versus Casey that the court would overturn Roe. It did not. 3 justices appointed by Republicans, known as the plurality, Justice O'Connor, Justice Souter, and Justice Kennedy, wrote an opinion in which they said they may not have decided Roe versus Wade the way it was decided in 1973, but it had become the law of the land, and women had grown to rely upon it. The famous quote is, "Liberty finds no refuge in a jurisprudence of doubt." So one question you might ask is, how long must a precedent exist before it becomes settled law and cannot be overturned? Does it matter whether the precedent is somewhat unjust, extremely unjust, whether the world has changed since then? The 2 most famous examples of the court's overturning precedents are the decision to overturn Lochner and find there is no economic liberty in the meaning of liberty in the 14th Amendment, and the decision in Brown versus Ford to, in essence, overturn Plessy versus Ferguson, a case that had upheld segregation. And in the Brown versus Ford case, the court said basically that facts had shown that the separate but equal in Plessy was never really equal, just separate. The larger question is, when can a precedent be changed? And the example I like to use is of Jell-O jelly. So you may remember when you were a little kid and you put colored water into the freezer or the refrigerator, and 30 seconds later you went and checked it and it was still colored water, and 60 seconds later you checked it and it was still colored water, and at some point it became Jell-O, one of those metaphysical miracles. At what point does the Jell-O become Jell-O? At what point does the Jell-O gel? In the same way, at what point does the precedent become settled law? You often hear Supreme Court justices in court testimony, confirmation hearings, say that Roe versus Wade is settled law. At what point did it become settled? So the plurality in Planned Parenthood versus Casey ruled that Roe, the precedent, was settled law. However, they found that the states could regulate abortion in certain circumstances. Basically, if it didn't impose an undue burden on the pregnant woman. And they reviewed a bunch of different scenarios, and they found, for example, that requiring spousal permission or spousal consent or even notification was an undue burden on pregnant women. In contrast, requiring minors to get either parental permission or authorization from a judge and a 24-hour waiting period were not an undue burden. We can ask ourselves whether history has proven that to be true or not. Some have argued that a 24-hour waiting period in rural states has become a significant burden on reproductive access for women. But that is the current standard and has been the standard for the last 30 years now. The standard is abortion restrictions are illegal unless they do not impose an undue burden on the woman seeking an abortion. There have been numerous efforts to overturn Casey and overturn Roe, all of which so far have failed. However, Texas recently passed a statute that you may be aware of, a fairly clever statute that tried to avoid the issue of abortion rights, Roe versus Wade, and yet in practice ban abortions. How did they do this? They created a civil right of private parties to sue anybody involved in the abortion process. So rather than criminalizing abortion, they allowed private parties, third parties, to sue for, I believe, $10,000 anyone engaged in the abortion process. Why did they do this? Because since the state is not acting, people who want to get abortions can't sue the state. They can't preemptively challenge this law because they have no standing. They would only have standing to sue once someone sues them, which will only occur after they've sought an abortion, and if they lose, they'll be in jeopardy for $10,000. Well, presumably, since there may be multiple suits, many more dollars for abortion clinics. The goal of this was to make it very difficult to challenge abortion law in advance. And the courts right now have upheld this temporarily. They've allowed it to go into effect while they review it. And fairly soon, probably during the course of the semester, we will have an answer to whether or not it is constitutional. I'm going to pause there because I've now spoken for half an hour. This is a very broad survey of the reading material for this week. Please feel free to reach out to me directly if you have any questions about anything. There's also what I call a cheat sheet in writing that explains all of these concepts and how they apply in under 2 pages that is available in the resource section. And I urge you to start there and work your way through and then possibly come back to the lecture. Hopefully we will have a fun week exploring these very challenging issues. Thank you.